The origins of our laws in British Columbia. Law can be defined as the enforceable set of rules that govern a society. In British Columbia, our laws originate from two sources, common law and statute law. Common law is a system of law created by court decisions and judges. It derives its authority from historical customs and the rulings of judges who originally resolved disputes based on these social customs. Central to this system is the doctrine of stare decisis. Simply put, stare decisis means to respect previous decisions and maintain consistency in applying legal principles. Once a court establishes a rule for a specific situation, it typically continues to apply that rule to similar cases in the future, regardless of the parties or property involved. Equity in law refers to courts administering justice based on fairness, in contrast to the rigid rules of common law. It embodies principles of fairness, justness, and right dealings that govern interactions between individuals. In the 1870s, the English Parliament enacted the Judicature Acts, merging the courts of equity with the common law courts. This fusion allows judges throughout Canada, excluding Quebec, which follows its own legal system, to apply both common law and equitable principles when adjudicating cases. In situations where common law and equity diverge, equitable principles hold precedence. Modern legal systems, including those influenced by the Judicature Act, often empower judges to grant both common law and equitable remedies based on the circumstances of each case. However, equitable remedies like specific performance are discretionary and may not always be granted, especially if there are delays or other equitable considerations. Common law traditionally provides remedies primarily through monetary damages, where the court orders the party at fault to pay compensation to the injured party. This compensation aims to put the injured party in the position they would have been in if the contract had been performed as agreed. Equitable remedies, which originated from the courts of equity, include specific performance and injunctions. Specific performance compels the party in breach to fulfill their contractual obligations as specified, such as transferring property or signing documents. Injunctions, whether prohibitory or mandatory, are court orders that either prevent a party from taking certain actions or require them to perform specific acts. Sample scenarios. Number 1. Monetary damage.
Alex, you've brought a claim against Taylor for breach of contract. Can you explain the situation?
Yes, Your Honor. Taylor agreed to deliver 100 custom-made chairs to my furniture store by June 1st. However, the chairs were never delivered, and I had to find another supplier at a higher cost.
I see. Taylor, what do you have to say in response?
Your Honor, I admit that I couldn't deliver the chairs as promised. There were unforeseen issues with my supplier.
The court recognizes the breach of contract. Now, Alex, you're seeking monetary damages. Can you specify the amount and how you arrived at it?
Certainly, Your Honor. I had a contract with Taylor to deliver the chairs for $5,000. Due to the breach, I had to pay $7,000 to another supplier. I'm seeking $2,000 in damages to cover the additional cost.
Thank you, Alex. Taylor, do you have any objections to this amount?
No, Your Honor. I understand that Alex had to pay more because of my failure to deliver.
Very well. The court awards Alex $2,000 in damages. This compensation aims to put Alex in the position they would have been in if the contract had been performed as agreed. Taylor, you are ordered to pay this amount to Alex.
Thank you, Your Honor.
I understand, Your Honor. I'll make the payment.
Case closed. Court adjourned.
Number 2. Specific performance.
Jordan, you've brought a case against Morgan for specific performance. Please explain.
Yes, Your Honor. Morgan and I entered into a contract where Morgan agreed to sell me a piece of land. However, Morgan has now refused to transfer the property to me, despite my full payment.
Morgan, is this true?
Yes, Your Honor, I did agree to sell the land, but I changed my mind and decided not to go through with the sale.
The court finds that Morgan is in breach of contract. Jordan, you are seeking specific performance, correct?
Yes, Your Honor. I want Morgan to transfer the property to me as we agreed.
Morgan, since you entered into a binding contract and accepted full payment, the court orders you to fulfill your contractual obligation. You are required to transfer the property to Jordan.
Understood, Your Honor. I'll comply with the order.
Good. This ensures that Jordan receives the land as originally agreed. Case closed. Court adjourned.
Number 3. Injunction.
Sam, you've brought a case seeking an injunction against Chris. Please explain the situation.
Yes, Your Honor. Chris is my neighbor and has been playing loud music late at night, disrupting my sleep and causing distress. I've asked Chris to stop, but the noise continues.
Chris, is this true?
Yes, Your Honor. I do play music at night, but I didn't realize it was causing such a disturbance.
Sam, you're seeking an injunction. What exactly do you want the court to order?
I'm asking for a prohibitory injunction to stop Chris from playing loud music after 10 p.m.
Chris, the court is inclined to grant this injunction. You are ordered to refrain from playing loud music between 10 p.m. and 7 a.m.
I understand, Your Honor. I'll stop playing music during those hours.
This injunction aims to prevent further disturbance and maintain peace. Case closed. Court adjourned.
Number 4. Competing claims.
Pat, you've brought a claim against Jamie for breach of contract. Please explain the situation.
Yes, Your Honor. Jamie agreed to build an extension on my house for $20,000. I paid $10,000 up front, but Jamie abandoned the project halfway through. I'm seeking $10,000 in damages.
Jamie, is this true?
Yes, Your Honor. I did start the project, but I had to stop due to unforeseen circumstances. I used the $10,000 to purchase materials and pay labor costs.
The court acknowledges the breach of contract. Pat, you are seeking monetary damages, correct?
Yes, Your Honor. I want my $10,000 back so I can hire another contractor to complete the work.
Jamie, do you have any comments on this?
Your Honor, I spent the $10,000 in good faith to start the project. Returning the full amount would put me at a significant loss.
This is a complex case. While common law would typically award Pat monetary damages, there is an equitable consideration here due to Jamie's partial performance and use of funds in good faith. In this case, an equitable remedy might involve specific performance. Jamie, you would be required to complete the extension as agreed, ensuring that Pat receives the benefit of the contract.
I understand, Your Honor. I can resume work and complete the extension.
The court orders Jamie to fulfill the contractual obligations and complete the extension. This equitable remedy ensures fairness, considering Jamie's partial performance and use of funds.
Thank you, Your Honor. I agree with this solution.
I'll get back to work immediately, Your Honor.
Case closed. Court adjourned.
Statute law, also known as legislation, is created by government representatives at 3 levels: federal, provincial, and municipal. Federal government. The Constitution gives the federal government the power to make laws. The federal government can pass laws on issues like banking, bankruptcy, currency, postal services, marriage and divorce, criminal matters, patents, copyrights, shipping, fisheries, and national defense. The federal government also has the power to make laws in areas not specifically assigned to other levels of government. Provincial government. The Constitution gives the provincial government the power to make laws. The provincial government is responsible for areas like property and civil rights, municipal institutions, the administration of justice within the province, education, and local or private matters. Municipal government. The municipal government gets its authority from the provincial government, not directly from the Constitution. Provinces give certain powers to municipalities, allowing them to pass bylaws on local issues like street and traffic regulations and building codes. Each level of government creates laws that regulate different aspects of our daily lives, ensuring comprehensive coverage across various areas. The legal system categories. Law can be broadly categorized into 2 major categories: private law and public law. Private law, also known as civil law, encompasses legal matters concerning relationships between individuals that do not directly involve the state. This includes issues like breaches of contract, divorces, and tort actions. Public law addresses constitutional principles, governmental bodies, and relationships between individuals and the state that are directly significant to public interest. Examples of public law include tax law, constitutional law, and criminal law. Here are some examples of private laws and public laws. Examples of private laws include contract law, tort law, family law, property law, and inheritance law. Examples of public laws include constitutional law, criminal law, administrative law, environmental law, tax law, and immigration law. The Judicial System. The judicial system is a network of courts that interprets and applies the law to resolve disputes and administer justice. It includes various levels of courts, such as trial courts, appellate courts, and a Supreme Court, each with specific roles and jurisdictions. Jurisdiction. In Canada, the court system is hierarchical and similar nationwide. Each province and territory, except Nunavut, has 3 court levels: lower courts, superior courts, and appeal courts. The Supreme Court of Canada is the highest appellate court. Each province and territory has a court of appeal and a superior court for major civil, criminal, and family cases, and appeals from lower courts. Lower courts handle minor criminal cases, family law, and small claims. In Nunavut, the Nunavut Court of Justice serves as a single-level trial court with comprehensive jurisdiction. Additionally, administrative tribunals are decision-making bodies that handle certain issues on behalf of federal and provincial governments when it is not practical or appropriate for the government to do so itself. Administrative tribunals. Administrative tribunals are not part of the regular court system. They are simpler, specialized bodies set up to handle disputes in specific areas. To make sure they act fairly and follow the law, some of their decisions can be checked by the courts. This can happen if they haven't followed fair procedures or if someone questions their authority. Each province maintains its own administrative tribunals to address local laws and regulations effectively. These tribunals offer specialized expertise and timely resolution of disputes tailored to provincial governance and specific regional needs, ensuring decisions align closely with local policies and priorities. Civil Resolution Tribunal. The Civil Resolution Tribunal, CRT, is an online tribunal created by the Civil Resolution Tribunal Act, designed to handle specific types of disputes. It is the first of its kind in Canada and deals with the following: strata corporation disputes, includes issues like non-payment of strata fees or non-enforcement of strata bylaws with no monetary limit. Small claims disputes, handles disputes involving amounts up to $5,000 related to debt, damages, personal property recovery, personal injury, or specific performance of agreements. For claims over $5,000, the excess amount must be abandoned. Motor vehicle accident injury disputes deals with claims up to $50,000. The CRT does not have jurisdiction over matters like libel, slander, claims against the government, or constitutional issues. It only addresses disputes arising within British Columbia. The CRT also handles disputes within housing cooperative associations, such as access to documents, meeting issues, voting problems, and enforcing bylaws or the Societies Act. Each cooperative must have a designated contact person for CRT claims. Phases of CRT Dispute Resolution. Negotiation. Parties communicate online to try and settle the dispute. Facilitation. CRT staff assist parties in reaching a settlement if negotiation fails. Adjudication. An adjudicator makes a binding decision enforceable by the courts if facilitation fails. Disagreements with CRT decisions can be taken to the BC Supreme Court for judicial review, though this process can be uncertain and legal advice is recommended. Advantages of the CRT. The Civil Resolution Tribunal, CRT, offers a modern, accessible, and efficient alternative to the traditional court system. Online process, convenient for parties with busy schedules. Efficiency, aims to resolve disputes within approximately 60 days. Lower costs. Fees are around $200, and the process does not typically involve lawyers, making it cheaper than traditional court proceedings, which require in-person attendance, take longer, and incur higher costs. CRT orders are enforceable in British Columbia's provincial and Supreme Courts. The tribunal is overseen by the Ministry of Attorney General. Trial courts. In each province, if a dispute is not handled by an administrative tribunal, it is first heard and judged in the courts of original jurisdiction, also known as trial courts. At this level, all evidence is presented, including oral testimony from witnesses, documents, and other relevant materials. The judge reviews the evidence, decides which evidence is credible, considers previous cases and statute law, and makes a decision. Small Claims Court. Small Claims Court provides a straightforward legal avenue for resolving disputes involving amounts of $35,000 or less. Designed to be accessible and user-friendly, it allows individuals to represent themselves without the need for a lawyer. In British Columbia, these courts handle disputes statewide, but cases must meet specific territorial criteria. The issue must arise within the court's jurisdiction. The defendant must reside or conduct business within that jurisdiction. Claims exceeding $35,000 can either be reduced or escalated to the BC Supreme Court for resolution, ensuring that disputes beyond the Small Claims Court's monetary limit are appropriately addressed. Supreme Court of British Columbia. The British Columbia Supreme Court is the highest trial court in the province, with no monetary or territorial limits on the claims it will hear. Actions can be brought before the court at any of its locations within the province. The court hears civil and criminal cases, as well as appeals from the Provincial Court of British Columbia. It has 90 judicial positions and 18 supernumerary judges, totaling 108 judges. Additionally, there are 13 Supreme Court masters who handle various applications in chambers. Appellate Courts. After a trial judge makes a decision, either party can appeal it to a higher court, called an appellate court. The party appealing is known as the appellant. Unlike trial courts, appellate courts don't re-examine all trial evidence, but focus on whether the judge applied legal principles correctly. If the appellate court finds errors in application, it may change or reverse the decision. The CRT may only seek a judicial review in the BC Supreme Court to challenge the legality or fairness of its own decisions, focusing on procedural or jurisdictional errors. A judicial review and an appeal are not the same, though they are related legal processes. A small claims court case may be appealed to the BC Supreme Court to seek a review of both legal errors and factual findings made during the initial trial. Appeals from the Small Claims Court go to the BC Supreme Court. The appellant must first show a judge that there were legal or factual errors in the original trial. If the appeal is accepted, a new trial may be ordered, where all evidence is reheard and a new decision is made. Appeals from the British Columbia Supreme Court go to the British Columbia Court of Appeal. Unlike trial courts with one judge, appeals are heard by a panel of judges, and the majority decides the case. Typically, 3 judges hear an appeal, but in important cases, 5 judges may be involved. A majority decision, such as 2-1, can overturn the lower court's decision. Regardless of which party wins in the Court of Appeal, they can request to appeal to the Supreme Court of Canada in Ottawa. However, the Supreme Court can choose not to hear the appeal, in which case the Court of Appeal's decision stands. Appeals to the Supreme Court are typically heard by a panel of 5, 7, or 9 judges. The evidence is not reheard, and the majority decision prevails. The British Columbia Civil Court System. Small Claims Court is the lowest trial court where claims up to $35,000 are heard. Cases are filed based on the defendant's location or where the claim arose. The BC Supreme Court is the highest trial court with jurisdiction over cases of any amount. Appeals from Small Claims Court are also heard here. There are no territorial restrictions within British Columbia. The BC Court of Appeal is the highest appellate court in British Columbia, where appeals from the BC Supreme Court on legal issues only are heard by a panel of 3 or 5 judges. There is no rehearing of evidence. Decisions are made by majority vote. The Supreme Court of Canada is the highest appellate court in Canada. It hears appeals on legal issues only, with the court's consent. Appeals are heard by a panel of 5 to 9 judges. The court does not rehear evidence. Decisions are made by majority vote. Legal proceedings. Bringing a claim and court processes. When a civil wrong occurs, the injured party may seek redress through the court system by initiating a lawsuit. Parties involved. Our legal system operates on an adversarial basis, where each party presents their case, and a judge or jury impartially evaluates the facts and applies the law to make a binding decision. In Supreme Court, the party alleging harm is the plaintiff, while the defendant defends against the claim. In Small Claims Court, they are referred to as the claimant and defendant respectively. Settlement and pre-trial process. Many claims are resolved before trial, primarily due to the pretrial process and concerns over court costs. This process begins with pleadings, where the plaintiff files a notice of civil claim and the defendant responds. Discovery procedures follow, such as examinations and document disclosures, to clarify and narrow the issues in dispute, often facilitating settlements. The trial. To succeed, the plaintiff must prove their case on the balance of probabilities, convincing the court that their version of events is more likely than not. Witnesses are examined under oath, cross-examined by the opposing party, and then both sides present their legal arguments. Judgment and court costs. Following the trial, the court issues a judgment outlining the parties' obligations and any remedies. Court costs, awarded to the successful party to partially cover legal expenses, are a consideration that may influence settlement decisions. Costs are separate from legal fees and are designed to discourage frivolous litigation by imposing financial consequences on unsuccessful parties. Alternative Dispute Resolution. Alternative Dispute Resolution, ADR, refers to methods of resolving disputes outside of traditional litigation in courts. These methods, such as mediation and arbitration, offer parties more flexible, private, and often quicker ways to resolve conflicts with the assistance of neutral third parties. ADR aims to reach mutually acceptable agreements or binding decisions without the formalities and costs associated with litigation. Mediation. Mediation is an alternative to going to court, encouraged by the BC government to resolve disputes more efficiently and affordably. In mediation, a neutral mediator facilitates discussions between parties in a private and informal setting. Unlike a judge, the mediator does not impose a decision. Instead, they assist parties in reaching a mutually agreeable settlement that addresses their interests and needs. Mediation can be voluntary or mandatory, initiated through a notice to mediate, and typically results in high satisfaction rates among participants in British Columbia. Arbitration. Arbitration offers another alternative to court litigation. Unlike mediation, where the parties reach a mutual agreement, arbitration involves an arbitrator who reviews evidence and arguments from both sides and issues a binding decision. This process is valued for its flexibility, privacy, speed, and the ability to choose an arbitrator with specific expertise. Enforcing a judgment. After obtaining a favorable judgment in court, the next step is enforcing it if the defendant does not promptly comply with payment. This can involve several methods depending on the circumstances. Examination of the judgment debtor. This involves identifying the debtor's income and assets through various searches and possibly examining them under oath. Execution. If assets are identified, such as a vehicle, they can be seized and sold to satisfy the debt, authorized by a writ of execution issued by the court. Remedies against land. If the debtor owns property, the judgment can be registered against it, preventing the sale or transfer of the property until the debt is settled. Judicial sale of the property may also be pursued. Garnishing order. Money owed to the debtor by a third party, such as wages or from a bank account, can be redirected to the creditor through a garnishing order. Certain exemptions apply to protect a portion of wages from seizure. Imprisonment for non-payment of debt is no longer allowed. Other legal actions, such as contempt of court, are required for such outcomes. Limitation periods. Limitation periods exist to ensure fairness and legal certainty. They encourage timely resolution of disputes, prevent the indefinite threat of lawsuits, and help preserve the integrity of evidence, which can degrade over time. By setting deadlines for initiating legal actions, limitation periods promote justice and stability in the legal system. At law, limitation periods set deadlines for starting legal actions once a right to sue arises. Missing these deadlines can bar a claim. In British Columbia, the Limitation Act sets a 2-year basic limitation period for most civil claims from the date the claim is discovered. There is also a 15-year ultimate limitation period from the act or omission, which can reset if liability is acknowledged. After these periods, the claim is unenforceable. In equity, which complements legal claims, timing is also critical. Besides complying with legal limitation periods, equitable claims must be pursued within a reasonable time frame determined by the circumstances of each case. Failing to act promptly can result in the denial of equitable relief. Therefore, litigants pursuing equitable actions must act swiftly to assert their rights effectively. If a court action is brought against you, it's crucial to consult a lawyer promptly to avoid accidentally acknowledging liability or resetting limitation periods. Additionally, be aware that a licensee's errors and omissions insurance plan typically requires immediate notification to the insurer of any error or situation that could lead to a claim. Prompt action ensures compliance with coverage conditions and helps protect your legal interests. Understanding the basics of law empowers individuals to navigate legal matters confidently. It fosters a deeper respect for justice and the rule of law, equipping people to make informed decisions, safeguard their rights, and engage effectively with legal professionals when necessary. In British Columbia, this foundational knowledge promotes responsible citizenship and informed decision-making, contributing to fairness, equity, and a cohesive community adherence to legal norms and protections.